I'd like to call the meeting to order. Got a roll, please.
Hopperly.
Here.
Barton.
Here.
Betteridge.
Here.
Jones.
Here.
Shook.
Here.
Spar. Here. And Warren.
Here.
Thank you. We have a quorum.
Everybody had a chance to look at last month's minutes? There are no amendments. Do I hear a motion for approval?
Mr. Chairman, I move that the minutes of December 21st be approved as presented and published.
Second.
Barton.
Yes.
Betteridge.
Yes.
Jones.
Yes.
Shook.
Abstain.
Spar.
Abstain.
Warren.
Yes.
And Hopperly.
Yes.
Thank you.
Our attorney's going to read just a brief statement about the zoning board.
Thank you. Tonight, we're holding a couple published hearings pursuant to, public hearings pursuant to published notice. Anybody wishing to address the board will be afforded an opportunity to get to do so. They'll give any statements or testimony they intend to offer under oath or affirmation. They'd approach our court reporter, Arlene, and she'll swear you in. At the conclusion of tonight's public hearing, the zoning board will take action on the matters before it. The affirmative vote of 4 members of the board are required in order to obtain the board's approval. In connection with the variance request, the question presented to this board is whether the proposed variance meets the criteria set forth by the village code. That criteria includes considerations of whether an actual hardship exists, which is caused by special or unique circumstances to the property at issue, not of the applicant's creation, and not generally applicable to other properties within the same zoning district. The question is not whether or not it's a good idea, whether the neighbors agree or disagree. None of those are a part of the question presented to the board. Simply a question of whether or not the evidence presented to the zoning board demonstrates that the request meets the criteria contained in the code. As a reminder of our rules of decorum, before anybody speaks, they need to be recognized by the chair. So when the chair asks if anybody wants to give testimony or comment, you can raise your hand and he'll acknowledge you and give anybody interested the opportunity to speak. Thank you.
All right, thanks, Pat. Okay, our first case tonight is continued from last month, case number 15-11. Brittany Garcia is requesting a variance for an accessory structure at 247 East Fernwood Street, zoned R1. Petitioner seeks a variance for the size limitations and allowable height requirements. Whoever's going to speak, Brittany, you want to stand up, be sworn in?
First of all, we'd really like to thank you for giving us this opportunity to present a different idea than what we had originally in our structure. I believe I handed out, or Mr. Spangler handed out a new drawing of the dimensions of what we're looking for. So essentially what we want to do is get rid of the shed that we currently have. That would allow us then the full 213 square feet, which is the 1.6% of our property size, for the additional structure. With the new dimensions, we'd be taking off that balcony from the previous images and making it a solid wall on the end. That would reduce the square footage of the treehouse to 198 feet, which would fit within that 213. In addition to that, the variance then that we would be seeking, since it would fall within that size limitation, would be for the height. And the hardship that we're encountering when we tried to reconfigure this was the size of the actual tree. So we can't lower it any because there's a giant branch coming out of it. And the posts need to stay where they're at to keep the support. So in addition to that, we took a lot of the suggestions that you have had last time into consideration, and some additions that we're going to do is, first, the shed's coming down. I've already talked to Mr. Spangler about putting up a privacy fence, a 6-foot, around our entire yard. And then we're also, I spoke with a village board member who came by my house unexpectedly, about planting some privacy, like a screening pine tree along that line and along the corner. So we would have the fence and the trees. It would take a couple years. I understand the neighbors aren't happy with the view, but we would be willing to make some alterations to help make it a better view for them. So in addition to that, we've talked about landscaping around the bottom, putting some ivy growing up posts, adding some shutters, flower boxes to kind of play up that dollhouse view that we are looking for. I believe that's it. So again, the height for the staircase and for the size of the tree are the two hardships that we're facing with keeping the structure at the current height, but we will reduce the overall square footage to accommodate the building code. Questions?
Does anybody else in the audience wish to speak to this case? You want to speak? I'll allow you to speak now if you want to stand up, be sworn in.
Raise your right hand, please. Do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. State your name when you get up there.
My name is Raleigh Krug. We live next door to the Garcias. I just want to reiterate some things that I said at the last meeting and a little bit more. During the December 21 public hearing, I spoke on behalf of my property located adjacent to the 247 East Fernwood Street property. I spoke of my concerns on property value concerning the sale of my home and the impact the accessory structure may have on said sale. I have had a real estate agent visit the property, and she believes the potential future sale of my property may well be impacted by the accessory structure and its visibility, limiting the number of people interested in buying my property. I spoke of the concern that I have regarding my inability to minimize the visibility of the accessory structure from our property at 241 East Fernwood and our newly installed four-season room. I am concerned about the future use of the accessory structure, as it may come to disuse in the future and be difficult to maintain by the current or future owners. I am concerned that the board placed me and my wife in an awkward position against the Garcias by requesting our opinion on proposed options to make the structure more visually appealing, instead of following the lawyer's advice and discussing the variance as if the structure did not exist. All these concerns still remain with me. I implore the board to address this variance as if the Garcias are requesting a permit for the two ordinance variances and not consider the building as built.
I'd like to apologize as far as the board if I offended you by asking. I just thought maybe two neighbors get together and hash something out. That's my fault, and I apologize. I didn't mean to pit you two against each other. That's never my intent.
Yeah, no.
And I don't, that's just,
Yeah, I didn't see it that way. I just saw it as a violation of the code and a variance request. It's not. It affects me deeply, but I don't feel myself against them.
okay, thanks. Does anybody else in the audience wish to speak? Brittany, would you like to make a comment?
Brittany, before you speak again, I'm going to interject one thing for the record to make sure, and you've already stated this, but I'm going to repeat and relate it to your request. It's my understanding that the petitioner has withdrawn the request for a variance on the size limitation, which would leave the only request pending before you, the variance for the allowable height requirements.
Correct. Yes.
I'll
Okay.
make sure everybody understood the.
Thank you, and I don't think I said last time, I'm Brittany Garcia at 247 East Fernwood. Kind of in response to Mr. Krug's concerns, we have kind of addressed those with the privacy fence and the trees that are going up regardless of what happens with this structure. I understand that you guys are in a hard position, but I feel like having a village board member show up at my house on Christmas Eve and an assessor show up taking pictures of my backyard without contacting us. Twice this has happened. I've seen strange men taking pictures of my yard. I have a little girl. That doesn't make me very comfortable. So the privacy fence is going up and the trees are going up too. Again, we understand this was not intended to be, obstructing their view in any way. But if we did make the structure conform to the current building code and we brought it down to the 13 feet, that's going to be right in the line of view, which we're still going to have some sort of structure for my daughter to play in. So it would still be the same square footage, only lower, which would be directly in your sight. So I'm just asking again for that variance due to the hardship of the tree size and the ladder to make it structurally safe for my kid. That's all.
I had a question.
Sure.
Since there's been a concern of the height of the tree and the size and all this, have you ever considered of rebuilding it on the ground and making a really nice dollhouse on the ground for your daughter?
She's 10. She's not really interested in a dollhouse at this point. And I understand they're saying it's going to go to disuse or whatever. We'll take care of it. My dad's a contractor. We plan on being there for 30 years. We just moved here in May. So it's not an issue of whether it's going to be maintained. Like I said, she's not really interested. We had considered the ground structure.
Well, the concern I have is for the next people that would have this property, and it would still be there, and it could be a problem. with
I
the
mean,
tree.
realistically, we lived there for 30 years. We're going to tear it down at some point. When she's 10, 15 years. Maybe I have grandkids that want to play in it. I mean, it's built well to last, but, I mean, we wouldn't necessarily leave it. We would plan on living there this was our forever home, so.
Okay.
And can I also say something about the
Yeah.
property value? We also talked to the realtor, and she feels that it would increase the value. And I talked to the assessor, who also showed up at our house, and she said that they're going to address that after this was all said and done. But with the one structure, she said she couldn't make any speculation at this time. But the realtor feels like it would increase the value because it's playing up to the family environment that's supposed to be Morton.
Okay, thanks. Does anybody else wish to comment?
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
My name is Ernie Smith, and I reside at 238 East Fernwood. Regarding last month's meeting, I thought it was conducted quite well. The attorney spoke, and it's still the same. It's not one neighbor against the other. It's an issue of conformance. Two questions that I have, as I was looking up some information, what is case 1601 before the zoning board? Is that a renumbering of 1511, or is it a separate case?
No, it's a separate case.
So, 1601, is that another petitioner requesting the same variances at 247 East Delwood for the same type of structure?
No, it's for a shed. It's on a ground type shed. I mean,
Okay. Yeah, because it just seemed to me it was kind of odd that they're both requesting a variance for the same ordinances as far as size and height.
yeah, no, it's just a square footage issue on that one.
Oh, okay. I was kind of concerned that we were getting,
Yeah,
as was one of the issues last month, the concern was, are we starting something here by allowing this to happen?
right.
You know, so the other question is as the structure stands now, would the zoning board have approved the variances for the two ordinances in question? And that's pretty much all I have to say. But I can share the concern of the Krugs, but I also know that, Garcias want something for their child.
Right.
So you guys are in kind of a delicate position.
Yeah,
You can't win.
yeah.
But I had these two questions, and that's why I stand.
All right, thanks,
Thank you
Larry.
very much for your time.
Appreciate it. So that being said, I think if we want to look at this thing, we haven't had tree houses for a height. I mean, as far as the height of a tree house is going to be higher than our allowable height most of the time. I mean, so if they're coming and asking for if we're going to vote on the new plan, I think that's what we need to talk about. And if anybody has any questions on the new plan, it's just pretty much the height is what we're,
I have a question to the attorney, McGrath.
Yes.
Are we still considering the point that we should be thinking about as if the structure has not been built, even on the
Correct.
second case?
That's correct. And the reason that's the case is because Our codes, my interpretation of that requirement is that you can't create your own hardship, so you can't find the existence of the structure being there and the fact that they'd have to take it down as being a hardship. That would basically enable someone to write their own variance by building without permit and then coming to you afterwards. And I know there was no intention to violate the code in this case, but that's the reason why you have to consider it as a new request, as if there's no building there.
Thank you.
You're welcome.
I would personally think if they're coming and asking for this variance right here, the only thing I would ask different if they were going to be for height. But I know we can change what the siding can be. You know, we can ask anything like that, but I don't know. You know, it's strictly about the height now.
Mr. Chairman, one of my concerns is that as the child grows up, which I think this is fine for the child right now, but as they grow up, it's going to get less and less use, but it still affects the neighbors. And it also affects us setting the precedent for anybody else in the village of Morton to construct a building of this size regardless. Personally, I would vote no, and that it should be restored to the approved ordinance only.
I agree with Mr. Betteridge.
I will say this much. You know, you stated that a board member showed up at your home, okay? To me, that's inappropriate. I don't have any control of that, and if that's what happened or gave you false hope, then I apologize on behalf of the village, because in my opinion, that should have never happened. So I hope you can accept my apology, as I would think that my colleagues would concur that that was inappropriate, and if it gave you false hope, then I apologize for that on behalf of the village. But I would be, without taking a formal vote, I would be in agreement with my colleagues at this point.
I agree with the apology.
And I don't know if, you know, what the precedence was when he stopped by, you know, I don't know. It was,
I mean,
I guess he
here's what it
didn't have any
boils
say
down
in
to.
it.
Here's what it boils down to. We live in a very good community, and I know that, you know, we ask, well, what can we do to make neighbors come together? And that's how, I think that's how we function as a board. We're probably a little different than what most municipalities are, which I can say I'm proud to be on this board, because that's how it is. It's not maybe the atypical as far as most municipalities would try to come up with a solution. It's not our job to come up with a solution. It's our job to look at it and say, is this something that works? Is it something that we can grant a variance on? If it's not, it's not. If it can, it can't. We try to accommodate, come up with ideas, which maybe we shouldn't, but it's one of the things that I find pride in as far as being on this board, trying to help people come together. So my position is we tried, and unfortunately, I think, at least the input from the other board members, without calling the actual vote, is try to come up with a resolution that works for everybody. But it is what it is. And I don't want to see neighbors get into disputes over anything, but that's my position.
I just want to say, we did not feel that the zoning board was out of line at all. We really appreciated you guys giving us this opportunity to begin with. I know the village board member acted outside. I know it was due to a letter being sent to them by our neighbors, and that's fine. I mean, I feel like there's been a lot of hard feelings after that last meeting, but it's nothing against you. You have all been very, very good with letting us state our case and try and come up with a different solution, and we really appreciate that.
You know, even on a tree house, this deal is, we don't see this too often. I mean, this is, I think, our first. And as far as the square footage, I know that's square footage for accessory structure, but if we look at the whole big picture as far as a tree house, now we're talking a different, you know, we're taking this building and you're putting it into a tree. I think that we'll have to address that later on, but with the height, and it's just, it puts us in a real, you know, I don't think I could vote on a tree house of that size. The tree house you guys had on Chicago Street, I think that was a cute, I mean, very neat tree house. But I I'm kind of leaning that way after everything we, talked about as far as trying to vote on it for height and really don't have an option.
Can I ask an additional question?
Yes, I tell you, Brittany, if you could just step up just so Arlene can hear you and everybody can hear you.
So if we were just trying to build a shed on that same space, it could be 13 feet high, correct, in the same square footage? Okay, so it would be reduced in height by a couple feet. What about if we took the walls down and just had a platform? Are there any rules against that, since it would fall within that square footage?
I don't know the legality of a,
It would still, it's a structure, it would still apply.
But it wouldn't be
It
above the
wouldn't.
height.
Right.
Well, and if that was to be your intention, I'd suggest you work with there are some nuances to that change, and I just suggest it'd be appropriate for you to work with Roger outside the meeting, since that's not a part of your request here today.
Okay, thank you.
does anybody else wish to speak before we?
I'd suggest procedurally for the board, I think I've told you a couple times what the standard is. If anybody has any questions for me before you vote, again, as a point of clarification, I've mentioned today and previously that you can't consider the fact that the structure's already there as being a hardship, and you have to find a hardship to approve the variance. That's not to say you couldn't find a different hardship as a basis for your vote. That's your guys' decision as a board to make. But in the absence of questions procedurally, unless the chair feels differently, it'd probably be appropriate for motion to second.
Does anybody else on the board have any comments?
Somebody raised their hand.
Oh, I'm sorry. Did somebody wish to speak?
She had her hand up.
Okay, I'm sorry.
I missed the last meeting, apologize for that, but is the village board going to be looking into doing something with an ordinance? I mean, this probably isn't the last time we're going to see something like this.
I
And,
can speak as the zoning and planning member, trustee of the board on this. We've discussed this quite a bit, Roger, and we've looked at our ordinances, and I know there'll be additional review on this. I mean, quite frankly, we have an ordinance that's been in place for quite a while. It was revised a couple of years back to accommodate some of the trends, some of the changes that we've seen. And it's worked, I think, by all accounts, up till now. So we'll take this into consideration and take a look at that, but I don't know if we necessarily come out with an immediate change to the ordinances because of this case. I don't commit to that until we get a chance to review.
I mean, I understand, we've got to work with what we have today, which is probably going to be unfortunate for the situation, but, if you're building a tree house, naturally, it's going to be higher. The height limitation for a tree house is going to have to be different than to put a shed to put your mower in. There's going to have to probably be something addressed there by the fact that it is up in the air. It's in a tree. So, there's going to be something that's going to have to be addressed there. But I think, if they would have come to us with this plan before it was built, I don't think we'd have probably thought twice about saying no to that, just due to the size of it. Most of the time, we think of tree houses as being 6 by 6 or 8 by 8 or something we played in as a kid, and that kind of a thing. But this is and the fact that it is up in the air makes it more visible to more people, which makes it more problematic, I guess, as far as the neighbors are concerned. But I'm just curious if there's going to be any looking into in the future about height restrictions for that kind of a thing.
Does the fact that has 4 posts on it, does that change or is a treehouse, or if it's mounted to the ground, is that considered a shed now? So anything you build physically in that tree is considered accessory structure then?
Yeah, our definition of a structure is anything that's on the ground. So the post, the building, slab of concrete, whatever, an arboretum type, arbor type thing, they're all forms of structures, and that's in the definition.
So if it's built in that crotch of that tree, that's still considered, I guess, because it's still on the property?
Trees on the ground, so,
Okay, so you're mounting, it's got to be,
yeah.
Okay, I didn't know if there's any.
And this is this is rare earth. I mean, this isn't our normal, we aren't dealing with this often, so.
So it may not need an amendment, but more just a clarification, right? I mean, we could,
I think to that, I think our existing code thoroughly covers this case.
Yeah.
Yeah.
So if there was to be a change procedurally, it'd have to, the plan commission have to hold a hearing to consider any change to the zoning code. So, you know, if the village board was so inclined to look at it further, it'd have to go to the plan commission. So there's several procedural steps that haven't started rolling for any change to happen. But I want to be clear that I think, and Roger and I have spoke about this outside the meeting, I think your existing code thoroughly covers structures like this. And even if there were modifications, the way it was connected, if it was entirely connected to the tree, it'd still be well covered by your existing code.
I think I mentioned in December, but I'm not quite sure now, that I did do some checking in the area anyway with the local communities, and no one has that I talked to had an ordinance on tree houses, so. I'm not saying there aren't ordinances somewhere, but I'm just saying in the area there were, that I talked to, there was not.
I do want to say I appreciate the Garcias and McKelveys, that they tried to make a change. I mean, they tried to do what was right, you know. It takes a lot to do that, and I'm kind of sad that it makes two neighbors go against each other like this, but that happens. I think with that, if we have no more questions, I say we're going to make a motion as far as what they brought in tonight.
Mr. Chairman, I would move that we grant case number 15-11 under 1010-2C, with the exception that they had reduced it down to 198 square feet, leaving it the same height, is what we would want to put into the motion for the change.
I'll second that motion.
Betteridge,
No.
Jones,
No.
Shook,
No.
Spar,
No.
Warren,
No.
Opperly,
no.
and Barton.
No.
Thank you.
With that, I apologize. It's just a tough deal for everybody. I guess the next steps, I don't know what we do for time frame or,
Well, that will be handled by Roger in consultation, I'm sure, with Tom and others, so.
okay. So I appreciate everybody's input on the deal. I know it didn't, it came out fine for some people. Other people it didn't. I'm sorry, just sometimes it doesn't work out that way. So, okay, with that, next case is 16-01. The Village of Morton is requesting a variance for accessory structure at 247 East Delwood, zoned R1. I don't know if
Pat, should I get sworn in?
Yes, you should.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Okay, as you received your packet on this particular case, the maximum allowable square foot print of a storage building for 247 East Delwood would have been 100, and it's 28 feet over what would have been allowed by ordinance. This permit was issued, don't know the date, sometime late this fall, and the petitioner actually did everything they were supposed to. Unfortunately, the permit should not have been issued because it is too big. So it was not a situation that they necessarily created because they came in and did the right thing, but the permit should never have been written.
I didn't notice, is that on a concrete slab? Or is that
No.
just? I think we had if we as a city incurred this problem, should it be our financial burden to make the shed smaller? I mean, do we have,
Well, I don't think that part's before us today, to the extent you find it germane. Well, let me back up. To your question, we have to find a hardship that is unique to this property or circumstance. And the fact that someone applied, I think the hardship Rogers testified to or would offer is that person properly applied for and was received or was awarded a building permit in error. So that's the proposed hardship. If you were to deny the variance, then that presents a more interesting question as to who's liable and what responsibility is, which I'd rather not tender an opinion on tonight, especially not having looked at that issue, so.
we're talking 28 square feet? I think, or roughly?
Their building is 12 by 14, 168 square feet, and I believe the number was 140 is what they were allowed by the size of their lot. And when I became aware of it, I first talked to Attorney Davies and said, well, here's what we've got. How are we going to fix this thing now, going forward, so.
I mean, I think here's the thing. People make mistakes, people make errors. The error is human, right? So I think, my opinion is, we made a mistake, unfortunately. And I'll be right up front and honest with you. I mean, I think whoever needs, and respectfully, counsel, I would, I understand we're not going to discuss who's liable or not liable, but if we issued a permit on behalf of the village and we made an error, we live up to it. It is what it is, we own up to it. Again, it just puts us in another awkward position, but I make mistakes daily. It's no big deal. You work through them. But given the circumstances, I would have to say that I would not grant the motion. It was an error. And don't want to stick the burden upon the homeowner. I realize 28 square feet is nothing, but we're also looking at a hardship. Is there a true hardship here? I don't see one other than the fact that, unfortunately, we made an error. But I'm not calling anybody out on that. So I do want to be clear that the error's made, we work through it. My position is we take care of it. And however that shakes out between the village and the homeowner, that's my position on it. It's a level playing field.
This goes back to setting a precedent for any other building, regardless of who's at fault, whether the city issued a permit or did not issue a permit. We just went through a case where the building was built. This one, I think, is only partial built. Am I correct on that, Mr. Springler?
It's not
This one
siding
isn't,
on it.
it's pretty much done. I mean, it's,
This needs siding.
they just need siding.
Siding is on. I would still say we stick with the ordinance and stay with the ordinance, and the village will have to work it out with the homeowner as far as whose responsibility is to make the correction and the changes.
I guess I would have a very hard time voting yes on this one after we just voted no on the same thing. I mean, I think we have to stay consistent as a zoning board, or we lose our credibility as a zoning board. And, we're talking about we have to go by what the ordinance is. And granted, I know 28 square feet isn't much, and the location of that, it's kind of out of sight. Would we have granted that variance? Yeah, we might have granted that one had it come to us beforehand, because it's not that much over. But, I can't in good conscience say yes to this when we just said no to what we just said no to, so.
Yeah, without a legitimate hardship, they can't be approved.
For a point of clarification, and this isn't in any way trying to shape your policy decision as a board, but I don't believe it's tendered by the applicant that the hardship is the fact that the structure exists. But I believe the tendered hardship is that a building was constructed based on a permit awarded in error. So I just, and I don't want to testify on the petitioner's behalf, but that's my understanding of the tendered hardship, which would be certainly a distinct circumstance from your prior case. But that's, you guys are the arbiter of what is and is not a sufficient hardship to justify a variance.
I mean, my position is that we have that structure come into conformity, and if that means the village has to assume some of those costs to make that happen, it's our mistake. We own up to it and we assume those costs. But I think to remain consistent on this board, I mean, that's the way I feel about it, and that's the way I'm going to vote.
Does anybody else have any comments? Yeah, does anybody else in the audience wish to comment? With that, do I hear a motion?
Mr. Chairman, I would move that we grant case number 16-01 under 10.10.2C as stated.
I'll second.
Jones?
No.
Shook?
No?
Spar?
No.
Warham?
Yes.
Opperly?
No.
Barton?
Yes.
Betteridge?
No.
Thank you.
Okay, so that'll leave that one to Roger and the city. Roger, you have any comments?
We do have 2 cases for February to date. We've got until next Monday, so we got a job next month.
Okay. Randy, do you?
Yeah, other than to thank the zoning board of appeals for due diligence on this case. As everyone stated, and everyone agrees, it wasn't easy, but thank you for your efforts and consideration.
And I do want to make one final comment, and that is to Cindy and Roger, as a member of the board, I want you to know that I appreciate you guys and appreciate everything that you guys do for the board and for the village. You're greatly appreciated. And, unfortunately, sometimes things happen, but, we work through them, and I think you guys do an excellent job, and I appreciate you guys. Okay?
Absolutely.
I echo that. Okay, with that, do I hear a motion for adjournment?
Mr. Chairman, I move that we adjourn for this evening.
Second.
All in favor?
Aye.
Thank you.
Thank you.